welcome back to another episode of Courts This Week presented by LiveLaw. I'm your host Ostika Das and I'll take you through the most significant courtroom developments from across the nation. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website www.livelaw.in. In today's episode, we are going to talk about the NewsClick arrests, the latest conviction of former MLA Mukhtar Ansari, a development in a sexual harassment allegation against Congress leader K.C. Venugopal, and much more. So let's dive into the headlines. On 3rd October, Delhi police conducted raids on the residences of prominent journalists associated with NewsClick, a news organization known for its critical coverage of the Indian government. Numerous suspects were questioned and their electronic devices seized under the Unlawful Activities Prevention Act following allegations that the portal received funds for pro-China propaganda. After the day-long search, seizures and detentions, the Delhi police arrested NewsClick founder and its editor-in-chief Prabir Purkayastha and Amit Chakravarti, the organization's human resources head under the UAPA. The day after they were arrested, the duo were remanded to 7 days of police custody. Although Purkayastha and Chakravarti challenged this remand order on the ground that they had not been provided with the grounds of arrest in writing, the Delhi High Court dismissed their pleas after concluding that the order suffered from no infirmities. Then this matter went up in appeal to the Supreme Court, which has recently issued notice and sought Delhi Police's response. In the meantime, the two UAPA accused were sent to judicial custody for 10 days, which was extended for 5 more days. In the latest development this week, a local court in Delhi remanded Purkayastha and Chakravarti to police custody again till 2nd November. This is a developing story and we will be back with more updates. A special court in Uttar Pradesh's Ghazipur district for exclusively trying offences against members of parliament and members of legislative assemblies has convicted former MLA Mukhtar Ansari in a gangster case dating back to 2010. In this case, Ansari was accused by the UP police of plotting a conspiracy to kill Kapil Dev Singh, a teacher by profession murdered in 2009. The 60-year-old 5-time MLA is presently lodged in the Banda district jail. This is Ansari's 6th conviction in the last 13 months. In June this year, he was convicted in the 1991 Avadesh Rai murder case. Rai was a Congress leader and was gunned down in broad daylight in 1991. In April this year, Ansari was convicted in another case under the Gangster Act lodged against him for his involvement in the kidnapping of Vishwa Hindu Parishad office bearer Nand Kishore Rangta and also in the murder of Bharatiya Janata Party MLA Krishnanand Rai in the year 2005. The Kerala High Court has admitted a criminal revision petition filed by the complainant in the solo sexual assault case challenging the acquittal of Congress MP K.C. Venugopal. The complaint is that the survivor was raped in May 2012 at Rose House in Trivandrum. It was further claimed that the CBI had filed a closure report concluding that there was insufficient evidence to support an offence against Venugopal. Dissatisfied with the magistrate's acceptance of the closure report and dismissal of a protest petition, the complainant approached the Kerala High Court, asserting that the investigation was biased in favour of the parliamentarian and sought to portray the complainant as having a criminal background. The complainant argued that dismissing the protest petition without examining her or other witnesses under oath was unjust. A single judge bench of Justice C.S. Dias has issued notice seeking the responses of the Congress leader, the Central Bureau of Investigation and the state government to the complainant's criminal revision petition. Next, we turn to a development relating to the Tanur custodial death case, which involves the alleged mistreatment of detainees arrested on drug possession charges in Tanur, Malappuram. For more context, in this case, 5 people were apprehended by the police earlier this year and reportedly taken to a torture center in Tanur. Tragically, one of them, Tamir Jifri, passed away in police custody the following day. This week, while considering a criminal writ petition filed by the father of one of the arrestees, the Kerala High Court directed the chairperson of the Kozhikode Legal Services Authority to file a report after investigating the allegations of custodial harassment and torture. The petitioner has claimed that when he visited his son in jail, he found his body covered in injuries inflicted by jail officials. During this week's hearing, the Kerala High Court analyzed reports submitted by the doctors revealing various injuries on the bodies of the detainees. On an earlier occasion, the court had directed the Deputy Inspector of Prisons to collect statements from the doctors who treated the accused and conduct an inquiry into the torture allegations. After reviewing these reports, Justice P.V. Kunnikrishnan deemed it necessary to conduct a further independent investigation, which is why he has now sought a report from the Legal Services Authority chairperson before deferring the hearing by 3 weeks. The Delhi High Court has declined a request to host the All India Muslim Mahapanchayat at the Ram Lila ground in Delhi on 29th October. An organization called Mission Safe Constitution that claims to be dedicated to promoting awareness of constitutional rights among disadvantaged communities had contested the Delhi police's decision to revoke the permission to organize this Mahapanchayat that was granted earlier. The organization argued that the event aimed to empower marginalized groups including Muslims, scheduled castes, scheduled tribes and other backward classes. However, the police deemed the event communal and revoked the permission, a decision which has now been upheld by a single judge bench of Justice Subramaniam Prasad. This judge pointed out the potential communal and religious connotations of the event's promotional material and the cultural significance of the period between the end of Shraddh and Diwali for the Hindu community, while rejecting the petitioner's contention that the revocation was arbitrary. At the same time, although this plea was dismissed, the court left open the possibility for authorities to reassess the organization's request after the conclusion of the festive season. The Delhi High Court has rejected a plea challenging the appointment of Nidhi Chibbar, a senior IAS officer, as the chairperson of the Central Board of Secondary Education through a bureaucratic reshuffle. The Independent School Federation of India had contested her appointment, calling for her removal and requesting the disclosure of records pertaining to her qualifications and experience for the position. Chibbar, in response, had filed an affidavit affirming her 48 months of experience in the education department in the cadre of director and above. Before the single judge bench of Justice Chandradhari Singh, her lawyer argued that the allegations made in the petition were unfounded and that Chibbar met the necessary criteria to fill the vacancy. The court, after reviewing the IAS officer's affidavit, concluded that the plea lacked merit and dismissed it. Justice Chandradhari Singh explained that the writ of quo warranto is issued only when it is found that the individual holding the public office lacks the essential qualifications for the appointment. In this case, however, Chibbar's qualifications were deemed suitable and the petition was deemed an abuse of the legal process. The Delhi High Court has granted police protection to a couple who married against their family's wishes. While noting that their right to choose their life partners was protected by the Constitution of India since they had attained the age of majority, the court stressed that even their family members could not object to their relationship. Despite their family's disapproval, the couple had married in April and have been living together since then. The couple approached the High Court seeking protection. The single judge bench of Justice Tushar Rao Gedela was informed by them that another bench in August had quashed an FIR registered by the woman against the man after she took a stand that she was forced by her own family members to file the case on false and frivolous grounds. After hearing the couple's submissions, the High Court directed the Delhi police to ensure their safety and prevent any harm, particularly from the woman's parents or family members. While the Delhi High Court protected the couple that had attained the age of majority, the Allahabad High Court dismissed a plea this week seeking the quashing of an FIR against a minor boy who was in a live-in relationship with a 19-year-old woman. The FIR was lodged against the boy under section 366 of the Indian Penal Code, which penalizes acts of kidnapping or abduction of a woman with the intent to compel her to marry against her will or to be forced or seduced to illicit intercourse. While rejecting his request to quash the criminal proceedings, the High Court expressed surprise that the minor boy, dependent upon his father, wanted to be in a live-in relationship. The bench was composed of Justices Rahul Chaturvedi and Muhammad Azhar Hussain. The Madras High Court has intervened on behalf of two Tamil women seeking compensation for the deaths of their husbands in Nigeria. The husbands had died in a 2013 accident while travelling in a company car in the African country. The petitioners had appealed to the court to facilitate the insurance payout and seeking directions to the Ministry of Home Affairs and the Ministry of Overseas Indian Affairs. On receiving the two women's representations, both ministries had forwarded the applications to the company and the Indian Embassy in Abuja for necessary action. However, this is not where their responsibility ends. Despite recognizing that their only recourse was to pursue legal action against the company, the court has stressed the ministry's responsibility to take appropriate measures through the Indian embassies. While acknowledging the court's inability to issue any positive direction owing to Nigeria's non-inclusion in the compendium issued by the Indian government for getting relief for Indian nationals who died abroad, Justice P. Pugalendi nevertheless directed the centre and the respective embassies to engage with the company adhering to the compensation norms in Nigeria, considering the petitioners' financial constraints and their inability to pursue litigation in Nigeria. We have more news from the Madras High Court. This week, the Madras High Court granted bail to 8 men associated with the now prescribed Popular Front of India who are facing terror charges under the Unlawful Activities Prevention Act. For more context, in September last year, the Ministry of Home Affairs published a Gazette notification declaring the Popular Front of India along with its various associates, affiliates or fronts as unlawful associations under the UAPA, citing their alleged connections with terrorist organizations and alleged involvement in acts of terror. This development came on the heels of two massive nationwide search, detain and arrest operations against the PFI and its members. After an UAPA tribunal upheld the ban on the organization, the Popular Front of India has recently approached the Supreme Court. Now, coming back to the 8 members of the organization detained for their membership. The complaint against them is that they plan to perpetrate terror to intimidate other religious groups perceived as anti-Islamic, posing a threat to India's unity, integrity, security and sovereignty. The 8 men, however, argued that the special court had dismissed their bail application without concrete accusations or substantial evidence. They contended that their arrests were based solely on their affiliation with an organization that was not outlawed at the time. Pointing to the physical training activities carried out by the PFI, the government law officer argued that the commission of a terrorist act or any act in preparation for the commission of such a terrorist act would attract the provisions of our anti-terror law. But the court observed that in order to bring an act within the meaning of preparatory, it should be proximate to the act which was intended to be committed. In the present case, though it was alleged that the organization was training people to throw bottles filled with water, when no petrol bombs were recovered, there was no proximity with the preparation and the alleged act. Accordingly, the bench of Justices S.S. Sundar and Sundar Mohan concluded that the documents collected by the prosecution did not link any of the appellants directly to the offences alleged, and therefore the special court had erred in denying them bail. The Madhya Pradesh High Court has declined to dismiss a criminal case filed against Coca-Cola for the alleged presence of fungus in a Maaza mango drink displayed by a retailer in 2013. In this case, a food safety officer had taken a sample of the drink on suspicion of adulteration. The officer's inspection revealed the presence of fungus on the neck and mouth of the bottle and the product surface, rendering it unsafe for consumption as per the Food Safety and Standard Act. Subsequently, a complaint was filed against 8 accused persons, including the petitioner. Then in 2014, a magistrate directed summonses to be issued against all the accused. The current petition was filed by Coca-Cola against this order. This week, the Madhya Pradesh High Court emphasized Coca-Cola's responsibility to ensure the removal of expired products from retailer stores, even if the items were not directly sold to end consumers by the company. The single judge bench of Justice Vivek Rushia also observed that it was still unclear whether the manufactured drink had reached the distributor and the retailer well before its printed expiry date. Concluding that such an issue must be decided at the stage of trial after relying upon sufficient evidence, the High Court refused to quash the criminal proceedings against Coca-Cola. Finally, the Gujarat High Court has rebuked the Ministry of External Affairs for its inaction in locating and repatriating 9 individuals who went missing during their unauthorized journey to the United States in March. The PIL filed in the case revealed that these individuals possessed valid visas issued by the governments of Dominica and Antigua. They had first arrived in Dominica and were on their way to Antigua with the ultimate aim of seeking asylum in the United States. Despite the High Court's request for a status report on diplomatic efforts, the centre's response indicated that local authorities and Indian embassies had not responded to the MEA's letters. Dissatisfied with this response, the division bench headed by Chief Justice Sunita Agarwal criticized the lack of concrete efforts to trace the missing individuals. The MEA secretary has been directed to submit an affidavit on the actions taken, and the court has further urged the government to focus on locations where individuals travelling without passports might be held. The next hearing is scheduled for November 29th. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audio-visual format, we need your support. So don't forget to do the Fantastic Six. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you've subscribed to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications, and lastly, swing by our website at www.livelaw.in for our in-depth reports. I'm your host Ostika Das, and I will see you again next time.